Hi everyone, Derek Johnson with Tatango.com. Today I'm at Innovista Law, home of the TCPA Defense Force. And I'm sitting down talking to attorney Ernesto Mendieta about nonprofit compliance for text messaging, and specifically the Telephone Consumer Protection Act, or the TCPA. So what do nonprofits need to know about complying with the TCPA when they send text messages?
Well, nonprofits have a special treatment, so any message that they send have a specific regulation under the TCPA. First, the FCC has exempted them from the requirement of scrubbing their numbers against the National Do Not Call Registry. Normally, under the TCPA, for any telephone solicitation, you cannot call the numbers that are registered in the Do Not Call registry, but nonprofits can skip that step.
Because, and maybe explain to me, nonprofits, they don't need to actually opt in to receive text messages from the nonprofit, or how do people in a nonprofit opt in?
Correct. Here we're talking about consent of when to receive, and we have to distinguish between residential and wireless. For residential, the consent requirement goes down, and you do not need previous consent to get a call by or on behalf of a nonprofit. For wireless and text messages to cellular phones, the consent requirement and level is also lowered. Under a normal text message, a telemarketing message to a wireless phone, you would need express written prior consent.
So if you're like a brand or retailer sending a coupon, prior express consent, written consent.
Prior express consent, yes. For nonprofits, you can avoid the written part. So it brings down the requirement to just express prior consent. So if you gave your telephone number to a company, to a nonprofit, we're talking about a nonprofit, it's understood that you consented to receive information about that nonprofit.
So if I was interested in nonprofit, I gave my email address, I filled out some info, I put in my phone number, and it didn't specifically say they were going to text message me. I was giving my phone number to the nonprofit. Maybe I support them. They could text message me.
Yes.
So that's why you would have, if you were a brand, you'd have to scrub against maybe the do not call list. But nonprofits, they don't have to.
Yes. Correct.
The
other requirement that they're relieved from is having their company-specific do not call list. Normally, what companies do is whenever they receive an opt-out request, they have a list in which they say, these numbers we don't have to call.
So in our system, we have like unsubscribed status. So when someone's subscribed and they unsubscribe, we have to unsubscribe them.
Yes. Nonprofits do not have that obligation. They can do it for best practices to avoid calling people, because if they're a nonprofit and they're trying to look funding and they're calling someone that already asked them to stop, it's going to be an issue, and there's not going to be any funding, and
they're not
they want to achieve their purpose.
Because at the end of the day, it's really the consumer that matters the most. Like, there's the law, but then also what makes sense for people, so you're not frustrating them or making them angry at your nonprofit.
Yes, correct.
So there's two different things. The first one was
the Do Not Call Registry. They don't have to scrub their numbers against the registry. And the second is the lower consent requirements. They don't need it in writing.
So you don't have to, like, what we call double opt-in, where they're texting out their phone. Now they can, right? A lot of nonprofits have double opt-ins and they opt in people. But you're saying that it's not required by the TCPA. They have an exemption, is that what it's called?
Yes.
So they have an exemption to doing that.
Yes.
Well, that's interesting.
Yes, and the other thing that we have to keep in mind is that the messages need to be made by or on behalf of the nonprofit. So they can hire agents that are looking funding for the nonprofit, and even those third-party agents that are calling on behalf of the nonprofit will have the same exceptions.
Oh, interesting. So it could either be the nonprofit or the agents, but they have to be representing the nonprofit.
Yes.
It can't be just like, we do business with those people, and now we're text messaging them about Chipotle or some other company.
It has to be on behalf of the nonprofit and with a purpose relating to it. Yes. You cannot add like, I'm calling about this nonprofit, but let me tell you about this other product that I'm selling.
This Ford car, that's amazing, or something.
That will get you in trouble with the FCC. The courts will see through it and know that the main purpose of that call was actually to do some telemarketing.
Market or sales. Now, what about nonprofits I know there's an exemption if you're not doing marketing or sales type text message, just in general. For nonprofits, what if they are selling something? What if they are technically, they're always marketing something. They're marketing a cause, they're marketing, give me donations. So all of that is exempt.
No, it needs to be related to their non-profit purpose. If you enter the area of marketing or trying to sell a product or trying to promote a service, you will be treated as telemarketing.
Okay, so promote it, like if I'm a nonprofit, I promote a car, that would 100% be,
yes,
bad.
It will end up being considered as solicitation.
Okay, but if I message my nonprofit members and I say, we have a new T-shirt out that has the name of the nonprofit on the T-shirt, and we're raising money by selling these T-shirts, is that kind of a gray area or?
Not a gray area. It's subject to analysis.
Okay.
If it comes to the FCC or a court to actually decide, but the example you're saying, for me, it's crystal clear that it's actually for the non-profit purpose. So
because it's about that nonprofit business.
Yes, and it involves a selling of a share, but it's part of the funding of the nonprofit.
Okay, interesting. Would you recommend nonprofits, no matter really what, to always consult an attorney?
Yes, I would always do.
Because it does sound like there are a lot of nuances here.
Yes.
Certain nonprofits, I'm guessing, are not exempt, maybe. I don't even know if that's correct. Are there like certain designations of a nonprofit that are exempt?
There's several categories.
Okay.
And they will all fall into the same.
Oh, so they all fall in.
Yes,
okay, so as long as you're a nonprofit.
Yes.
Okay, interesting. Well, again, nonprofits, if you're listening, text messaging is great, but there are some exemptions. It makes it a little easier. You don't have to have the same qualifications, I guess. What was your wording?
Yeah, the IRS can give you a certain qualification, but you could also be a certain program or a certain association with a different certification. You would still fall with the TCPA exemption.
And it's just a lower barrier. You're not exempt.
You're not exempt.
It's just there's a lower barrier to your compliance, I guess.
Yeah, we can say a lower barrier to the consent requirements that you need to receive.
So even if you are a nonprofit, definitely consult an attorney because there's a lot of nuances. But again, I'm Derek Johnson with Tatango.com here at Innovista Law, the home of the TCPA Defense Force, and we are talking TCPA compliance for nonprofits. Thanks for watching our video today. If you like this video, be sure to give us a thumbs up on YouTube. If you want to see more of these types of videos, be sure you subscribe to our YouTube channel. And if you have comments or questions, please leave a comment or question in the comment section below.